Hunt versus Boulder City, C334314.
Good morning, Honor. Craig Mueller, Mr. Hunt. He's present of custody.
All right, Mr. Mueller is present representing Mr. Hunt, appellant, who is also present. All right, who do we have today representing Boulder City?
You have Gary Booker, Your Honor, as well as Lauren Oliver as well.
All right, hello, Mr. Booker, and hello, Mr. Oliver. Is that Lauren Oliver?
Yes, Lauren.
All right, very good.
Good morning, GB.
How you doing, Craig?
All right, so I'd set aside a little bit of time for argument. Mr. Mueller had filed a motion for reconsideration of this court's prior order regarding the issue of vindictive prosecution. Let's go ahead and hear argument from Mr. Mueller.
Thank you, Your Honor. And just a little personal history I'm going to draw upon with my experience with Mr. Booker. Mr. Booker and I started the DUI team together back in '95, I believe it was. When we started the DUI team, and I guess I'm getting to be an old man now because I start all my cases with stories, which is, I guess, the hallmark of a lawyer who's been doing this a little too long. Mr. Booker and I started the DUI team together, and we had the idea, in fact, I think it was mostly my idea, to go over and screen the DUIs at the police department. I actually went over to the old city hall and would sit there, and I would get about 2 or 3 bankers' boxes of recent DUI arrests. And I mention this because DUIs are the most complicated misdemeanor in the practice of criminal law. There are, and frequently, as complicated or as many other felony cases. So I want to put this in perspective. I would come in and I'd sit down about 8 o'clock in the morning, and I'd have 2 or 3 bankers' boxes at a desk at the Metro Traffic Unit, and I would screen about 100 and 150 misdemeanor DUIs. Declarations of arrest, blood draw withdrawals, probable cause, witness list, everything essential to put together a case, and then routinely read at least 2 or 3 paragraphs of the complaint to make sure it actually made sense. And in those days, you could get a DUI by sitting in your car in front of a bar waiting for your ride. So we had to kind of sort through the weeds a little bit and pull the cases out. With that perspective, I could get through 3 bankers' boxes, 2.5, 3 bankers' boxes in a day. And then I would bring them over, and occasionally Mr. Booker would take exception to what I'd screen, but not very often. And I'd bring those files over, or they get sent over by courier the next couple of days. When I read this affidavit that this case sat on somebody's desk for 8 or 9 months being investigated, I can't think of any polite way to say this. That's bovine scatology. It's just nonsense. You got this case right the very first time, Judge. You got it right. This is vindictive prosecution. You can refer to and attach to our pleadings is the affidavit of Mr. David Olson, who determined he was going to be retired. He got served, and this is his own language. On May 31st, the city was served with a federal rights complaint, civil rights complaint, and promptly he refiles his lawsuit that he had voluntarily dismissed and had been litigated. This is the quintessential textbook vindictive prosecution. Now,
well, that's what I thought originally, and then they came forward with an affidavit saying that it was overlooked, and they were reminded of it. And one of the reasons it was overlooked is he was getting ready to retire, and then the paralegal had a baby. And I know that only covered part of the time, but that was the new stuff they came forward with, and so I'm still trying to incorporate your new arguments with that set of circumstances.
And respectfully, Judge, and I understand, and no matter what, you can either be trained as a young lawyer in the criminal law, the civil law. For whatever reason, we tend to be kind of, just one of those things in our profession no one teaches you in law school. I was trained early on in criminal law, and I'm learning civil law later. Okay? So here's what I've got. I've got Mr. Ellison's affidavit. And in civil law, if a guy comes in and tells you, hey, look, the file's sitting there, it's been sitting there a few months, it's no big deal. And it really isn't. Complaint got put aside, got stuck in it. And I understand exactly why you would think that. Having said that, I want to read from page 64 of Mr. Olson's affidavit or transcript. Now, remember, he told you he got lost, and we was getting ready to retire. I sat there. Page 64, line 3. Well, I quickly prepared this complaint to meet the deadline. There wasn't any filing, wasn't any investigation. I quickly made this complaint to meet the deadline. It occurred to me this other offense that occurred, and that was interfered with the lawful activity that the police were attempting to perform at the intersection, and is indeed a different violation, so I included it there. Here he says, the file's sitting on my desk, it's voluntarily dismissed, and I know, and Mr. Booker knows, and I'm sorry I have to put him personally a little bit on the hook, but he knows that they don't investigate misdemeanors for more than about half an hour, 15 minutes, a phone call even. That this thing is sitting on someone's desk for months and months at a time is nonsense. It is prima facie evidence of vindictive prosecution. So here we have Mr. Olson's statement. Now, if you want to, I've got the videotape queued up. You can actually see what he said, which is contradicted by what he put in his affidavit, which is why I'm standing here asking the court and renewing the motion to dismiss for vindictive prosecution, because it is, in fact, vindictive prosecution.
So let's hear it.
Sure, absolutely.
So what's this new, explain to me your understanding of what count 4 is.
Well, as I was quickly preparing this complaint to meet the deadline, it occurred to me that there was this other offense that occurred. That is that he interfered with a lawful activity that the police were attempting to perform at that intersection. That is indeed a different violation, so I included it.
Stop it there. Now, Your Honor, that is what he said on.
All right, so that's what you already just
Yes, sir.
said to us in your argument.
That's actually the video of the transcript that I just read to the court. Now, one of these things is not in the same universe as the other. The court smelled the fox in the hen house the very first time. You had it right. You then, understandably, gave professional credit to representations of counsel that maybe there was some research needs to be done. Okay. And it's logical from a civil perspective, that's logical to do. From a criminal perspective, that's nonsense. And he basically says it's nonsense because he says, I quickly prepared the complaint. Right. And that the new charge, okay, you're going to law school. I promise I'm going to put you in law school if you interrupt me again. All right. Mr. Hunt is very bright and very engaging and obviously very involved. I apologize, Judge. All right. The answer is here it is. Here's my civil complaint. I had to research. I had to do some research, go back to the stacks, pull dust off the books, do the research. A legitimate understanding from a civil perspective. Civil law frequently is more complex, significantly more arcane. And it is. That's one of the hard lessons I've got in midlife. Criminal law is shoot from the hip, go, 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 move, shoot and scoop. Now, nobody studies a criminal misdemeanor file for 9 months. He filed it when he got served with a civil lawsuit, which is exactly what he said he did. And then when questioned, he says, oh, I filed it quickly. Well, that's filing quickly is not doing the research, okay? And it occurred to him to file additional charges, which is the soul of vindictive prosecution. Soul of it. That's what the whole concept is from. I'm going to file charges because you pissed me off. Pardon the language, but I mean, in the vernacular, you pissed me off. There was nothing in the federal lawsuit, which was subsequently dismissed, that said there wasn't vindictive prosecution. Nobody ever said there wasn't vindictive prosecution. They only said it didn't amount to civil liability because there was no pattern to it. Now, respectfully, Judge, I believe you got this right the first time. I believe this case is vindictive prosecution. I cannot reconcile these two fundamentally different assertions. You've seen what he told you in writing. Now you've seen what he said in person. It's not the same thing. You don't quickly...
What was the date of the video that you just showed me? The deposition.
I'm sorry, sir?
The date of that deposition.
The date of the deposition, one moment, Your Honor. I've got it here. December 12th of 2017.
So this is a motion for reconsideration, so I have to look at the context in which it's presented to me. Obviously, I can't sit here and re-exercise discretion and try to second guess myself. What I need to know is there some clear fact that I misapprehended, or or is there some clear error that the court has made, and you'd have to articulate what that error is, rather than me simply reweighing the evidence or re-exercising my discretion? What is the error that I did in my analysis?
Well, two things, Judge. Respectfully, this is criminal law. Mr. Hunt's volunteer has constitutional rights, and they can always be asserted. I can ask for rehearing after rehearing on the issues, so that it's not a civil lawsuit where I'm fighting over with some other guy over money. Hey, we've already heard this, move on. Okay? And candidly, two people fighting over money, nobody particularly cares that much except the two guys and their lawyers. I understand. That's not this case. This case is the government, state of Nevada, operating through its agency, the City of Boulder City, versus Mr. Hunt. There is, okay? It occurred to him after he was sued, it occurred to him that a new charge had occurred. That is the soul of vindictive prosecution. Occurred to him after they'd been sued. Now that's the word. Would you like to address the judges?
Yeah, please tell Mr. Hunt that he has to remain quiet.
Okay, I understand. Putting a motion behind the facts are before the judge, but putting a motion behind the facts don't change the facts.
Well, and it's just because it distracts me from what you're trying to say, Mr. Mueller.
I understand. Line 5 is what he's exercised about, Judge.
Okay.
It occurred to me that this other offense that occurred, this is in the context of a new charge being added after the civil lawsuit was filed. That in and of itself is an admission of vindictive prosecution. Now, the court may misapprehended that, or the new fact that's been added that the court misunderstood is that Mr. Olson admits vindictive prosecution. It occurred to me that the other offense that occurred, and there we go. He says this thing's sitting on his desk. No, it wasn't. It was sitting in a pile of dead paperwork that was probably getting ready to go off to storage, my guess. Instead, he gets a civil lawsuit, and he goes, resurrects an old misdemeanor. And then it occurs to him, he says it's excusable neglect as a civil lawsuit, and he says it occurs to him here that the charge. Okay, so respectfully, Judge, you got this right the first time. There is no reason for reconsideration to grant the city's motion to put it back on the docket, and the case should be dismissed. And may I get a moment to confer with my client?
Yes, of course.
As he was quickly preparing this complaint to meet the deadline.
I've read it to the judge.
I've presented it in its entirety.
For the third time, I will present this again to the court.
Of course, thank you.
Mr. Hunt is concerned that this doesn't, context is all important. Well, as I quickly was preparing this complaint to meet the deadline, comma, the complaint was being prepared to meet the deadline, not research, comma. It occurred to me that this other offense occurred, comma, and that it interfered with a lawful activity that the police were attempting to perform at this intersection, comma, and that indeed a different violation, comma, so I included it.
Yeah, apparently, if I recall correctly, this has been going on a while. 2 different officers issued citations, and citations from one of the officers was in the original complaint, and then they added charges based on citations by the other officer.
Yes, sir.
And it sounds like, so what he's saying is he learns of the civil rights action. Looks like nothing, it sounds like nothing was done on the original complaint, and the civil rights action gets filed, and then they look back through the file and they decide to add the new charge and then quickly get it filed and to meet the deadline. I don't remember what the deadline was. I think once you dismiss, there's some deadline before you can reassert.
1 year. 1 year from the date of the incident for misdemeanors.
1 year. Okay. All right. Right. No, I remember those facts. Now, thank you, but you put them in a little bit better context for me.
Right.
All right.
And I want you to understand, when we were screening those misdemeanors, if a police officer didn't have a document in there, we simply didn't file the charges. And if they didn't get it to us within a few weeks, it was dismissed, never to be seen again. But this thing is sitting on someone's desk for 9 months. Or whatever, 7 or 8 months. It's laughable. Literally, I'm sorry. but laughable.
Right. So I guess the question is how do I incorporate what you've told me today into my analysis, where obviously this court didn't have the perspective of how much time are spent on these types of misdemeanors as opposed to more complex DUI matters, and then the court being apprised of how quickly even the DUI matters get resolved. So it's based on what you're saying in your practice and experience, that this is something that would have been resolved like within a half an hour in terms of determining what to include in the complaint. And,
Yes, Judge.
And it's, you're, in your words,
It's
I forget what that word was. We'll just say ludicrous is what you're saying.
It is.
You had some kind of other weird word, but you're saying that it's just unfathomable for anyone to believe that it would just sit around because there's some big investigation going on about what other misdemeanor charges could be asserted.
Yes, Judge. That just doesn't happen in the real world.
All right. And so, but how am I allowed, sitting up here in a motion for reconsideration, to rely upon, that anecdotal information you've provided to me?
Yes, Judge. We're all officers of the court, and Mr. Booker is free to stand up. But the law is very clear. This is vindictive prosecution. He's entitled to relief by it. You saw that correctly the first time. He says that it occurred to him as he was rushing to meet the deadline. Now, hypothetically, you've practiced law. Mm-hmm. Why is someone rushing to meet a deadline? If the thing's sitting on his desk being researched, it's sitting on his desk. He would have the sticky with the deadline on it. Now, he gets served with a federal lawsuit. He was rushing to meet the deadline, which means he wasn't going to refile, and then he files. So, respectfully, I believe that you can, in fact, take a full appraisal. You are entitled to reverse a ruling in light of additional evidence. All right. Mr. Hunt's got a little more procedural familiarity. The matter's been around for a while. He testified, Your Honor, respectfully, that the complaint had been prepared and it was sitting around. Okay, that was in his affidavit. The complaint was sitting around. Then he says, when asked, he rushed and added charges quickly after the civil lawsuit. That is vindictive prosecution. You can incorporate it because it is, in fact, the state of the evidence and is newly presented evidence. So I don't think you have any trouble going back and dismissing this case, Judge, with prejudice.
All right. So you've been fully heard on that. Thank you. Appreciate that. Now, Mr. Booker, then I'd like to hear your response to all of those points.
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Best interest is not, can you give her a pony?
To ask the question, make sure we're being accurate with what it actually states.
Overruled. Let's just get through this. I want to know what the facts are.
To find out what the facts were. I agree, the record's a mess.
Okay, Your Honor, I'll start out. First off, when Craig went to work for me, I was the chief of the team. It was my team. I put the team together myself. Craig came on, he was down to the youngest member, which is why he was down there doing the complaints, because that's what the new guy does. DUIs in the DA's office are different. We have criminal deputies. I had 4 guys, including myself, which were dedicated to the proposition of doing nothing but DUIs. They came in fast, they came in heavy. And that's not the way things work here in Boulder City. I've been out in Boulder City now for 16 years, and I see the difference between a city attorney's office and the difference between a district attorney's office. It's night and day. It's Mayberry versus New York City. It's totally different here. Now, in this particular instance, Dave was the person, he did all of the screening for all of the criminal cases, period. I had never participated in screening cases until Dave left. That's our number one. And also, I would note, Judge, that Dave also was required to do all of the civil cases as well. He would farm certain things out to the different law firms, depending upon if he had a specialty in it or not. And in a lot of cases, he would do himself and go to court and trial. So it's a totally different picture than a DA's office, where you got machine gun at it and you got 15, 20 DUIs every day. The DA, we probably had 2,000 or 3,000 DUIs a year in that office with 4 people. So that office functions entirely different than the way we function here in Boulder City. I was raised in Elko, Nevada. I know the difference between a small jurisdiction and a big jurisdiction. Vegas is a huge jurisdiction, and in Boulder City, it's 15,000 people. It's not near as huge as Vegas. So there are some big differences there. And we have a prosecutor who also was the person who was doing the screening of the civil cases. So that wasn't uncommon for Dave to go back and forth, I think, between doing these things. Right away I want to dispel the notion that this is the same as Vegas, because it just isn't. And Mr. Mueller's comparison of Boulder City to Vegas is like comparing a mouse to a hippopotamus. They have nothing to do with each other. Next idea that we talked about, we know that Dave testified during our hearing specifically to these issues. Not only did he have an affidavit that you see on his affidavit, and when you read the affidavit essentially says that I was busy I was in the process of retiring, number one, and there's no paralegal to help him at that time. And I know for a fact that's the case. I was down here at court. I wasn't up in the office working with Dave. Occasionally, I would go up there to ask him questions, and I'll admit I saw the 2 piles that Dave made reference to a long time, and they were pretty big, and he was in the process of retiring. So my theory was leave Dave alone. Okay, Judge, in the court hearing, during Dave Olson's testimony in the evidentiary hearing, he went into great detail with you to kind of flush that out with you, saying I was doing all this civil stuff. I had the criminal stuff to do. I had already drafted and prepared the new complaint reference, Mr. Hunt, but I did not file it. The reason that he had to take time on it, and the reason he drafted that original motion, that original thing of the reason he drafted the amended complaint, is that he had went ahead and he did something that you never do in a criminal office. He dismissed the case and did a document saying it's without prejudice to refile. Normally, a person that does a lot of criminal will tell you they don't do that. They're going to continue a case if they have to add stuff to find stuff out, and you keep it in the loop. You don't do what Dave did. But he was being polite, and he did it the right way. But that's not the norm, Judge.
So remind me, Mr. Booker, what is the additional research that he conducted?
I was getting ready to tell you that. I was getting ready to go into that, Judge, now. Judge, okay. He was waiting on videos from the Nevada Highway Patrol. They did not come in, and I think he makes reference to that in his affidavit. He was waiting for the videos, and he had to wait till he saw the videos. And then when he got the videos, he went ahead and he drafted the amended complaint. What he did is he set the amended complaint to the side, and I think he probably pretty much forgot about it. And then what happened when Mr. Stubbs filed his civil action, he realized, hey, wait a minute, have I filed that complaint? He looked up and realized he hadn't. By then it was 4 days before the year would have run out, and he went and he took the walk, the 5 minutes it takes to get from the courthouse, from his office to the courthouse, and he filed the complaint that day. It doesn't make a difference when he filed the complaint as long as it was within a year. It doesn't mean it could be 4 minutes, it could be 4 hours, it could be 4 days, it could be 4 months, it could be 5 months, 6 months, 11 months. As long as it's done before the 12-month deadline, and that's what happened. There was nothing vindictive about anything that Dave Olson, I worked with that man a long time. There's not a vindictive bone in his body. I sort of resent Mr. Mueller trying to go in a different direction, but that's just my own nuance. The next thing after Dave reviewed the videos, he drafted it, put it to the side, and that's where he left it until he was prompted by Mr. Stubbs' big thing. Well, did I file that? He goes through his stuff. He realizes, oh, I need to get this down here. He gets it down. He filed it with the additional charges, Judge. So he had to review the videos. I don't know exactly when he got the videos, but he obviously reviewed the videos because he added things that only would have been involved. You could only see by looking at the videos that have been presented to him.
So hold on. If it's that easy to, walk over a few minutes, get it filed, if he drafted it, why set it aside at that point? Why, if you drafted it, you really want to...
Frankly, I think he just set it aside. Pardon? Yeah, he has paralegal was gone, Judge.
So nothing's getting filed that whole time when the paralegal's gone?
I think he was tended to a lot of civil matters as well, Judge.
Yeah, no, I remember that. I'm trying to remember his testimony on that. All right.
His testimony has not changed from his affidavit, none in the least. All Mr. Mueller did was get the deposition recording, give you a snippet of it. But if you read the entire deposition, it clarifies all of that. There's nothing. I just didn't like the hurried effect that Mr. Mueller was trying to push on you. That he could have done this. This man had a lot on his agenda. He had his retirement. He was arguing back and forth with the city council about things. There were a lot of things happening. I knew they were happening. It wasn't my place to intervene. I wasn't asked to intervene, and I didn't intervene. I didn't start drafting the complaints until Dave said, "Hey, Gary, you're going to have to start drafting complaints because I just retired." I know how to draft complaints, criminal ones, because, well, that's what I do. And so I took it over at that point, about the time that I took it over after Dave left, not before, the drafting complaints, and I still do them now.
Oh, go ahead.
We also know that you heard his testimony from his mouth to your ear, and this is, I think this is consistent with what I'm saying. There's nothing inconsistent here. Mr. Mueller may stretch and he may pull, but you can't pull a rabbit out of a hat, or pull a hippopotamus out of a rabbit's hat. There's nothing there. There was no vindictive prosecution here, and the case was filed within the 12 months. And those things that Mr. Stubbs and now Mr. Mueller are arguing, they had nothing to do with anything on this. They wanted. I know Dave for, like I said, a long time. And there's not a vindictive bone in his body. And I know how hurried and how rushed he was during that. There was a lot going on, the city council stuff. Because in Boulder City, you go to city council every other week. So I mean, that's typically a 2 or 3 hour affair, sometimes 6. Just depends on what they're dealing with. So he had that on his agenda. He was constantly doing things. But when he got the video, he looked at it. He changed the complaint. Knowing Dave, he probably set it to the side with the intent to file it, and then got busy doing other things. And he didn't have Chair Thackeray there to keep him oriented as to what time and date this thing has to get by. Then all that happened was, is that Mr. Stubbs decided he was going to file the civil matter, and when he saw that, he goes, wait, did I file the criminal complaint? He looked over, he realized he had to file it, and I assumed that's when he came down and he filed it. But he had drafted it after he got the videos, and I can't tell you when he got the videos because I don't know myself. But I know that he got them because we eventually got them ourselves later on when I went to trial on it. When by the time we got there, when Steve was now the city attorney. Steve Morris was the city attorney. So there's nothing ill-gotten. There's nothing vindictive. This is just normal stuff. This is Boulder City. The total staff right now is 3 people. We have the city attorney, who is the now acting city attorney, and she's learning the job and she's doing things. There is Lauren, who's with me, and then there is me. Lauren is a lawyer, but she kind of does a little bit of civil, and she does some criminal as well. So, and that's it. We don't have any runners. We don't have investigators. We don't have somebody who can go sit at the complaint down at the jail and draft complaints all the time, because it's just not that kind of practice. I think probably we get maybe 300 criminal matters a year, Lauren, give or take. Yeah, maybe 300 matters altogether. And that's the normal thing. We get citations for traffic tickets. I'm not counting those as criminal matters because they're not really criminal matters. So it's a different world here. And Dave is not vindictive, and I sort of resented the implication that Mr. Mueller was making, that he was, because I know much better than that. And I know how a big office faction works because I was in there for almost 18 years, and I know how a smaller faction works because I've now been out here for almost 16 years. So, and there's a big difference. And no discredit to Mr. Mueller, but I think he's playing in the margins here, trying to find something to hang his hat on. And I'm just telling you, there's nothing to hang his hat on here relative to Dave Olson and the preparation of this complaint. And we got it. The complaint was filed within the year. Like I said, 4 hours, 4 days, 4 weeks, 4 months. It doesn't make a difference. It's within a year. And that was accomplished here. And on that, Judge, I think I would submit the matter to you.
I have two points or questions. You were talking about what's normal. What is normal, though, regarding how many misdemeanor complaints were getting submitted by the city attorney's office at the relevant time here, at the time that the amended complaint against Mr. Hunt was filed? What was normal then on how many are done per week?
I'm going to ask Lauren that question.
Okay, thank you.
Less or more than what we have, Judge. It's not unusual to get the numbers up at the 400 or 500s. It just depends. But most of the time, it's a little smaller than that, seems like. But I have no idea.
Okay.
Complaints they come in, I get the police reports, and I review them. And I draft a complaint based upon it. But back then, I wasn't doing it. Dave did all of that stuff. All I did was take the cases to trial and try to negotiate cases from time to time. But other than that, the rest of that was done by Dave. I think he liked the criminal, and I think he liked doing the civil, too, to be honest. I think he sort of enjoyed the criminal stuff. For example, Dave did BDVs while he was here. I didn't do any of those until after Dave left, battery domestic violence cases. So there are things that he cherry-picked and kind of kept, and he did those as a part of his practice. And this complaint was one of them. I was unaware of this thing's existence until way after the fact.
Back there, then, at the time the amended complaint was filed against Mr. Hunt, how many misdemeanor trials were you conducting on average per month?
Oh, Judge, it's something. It could be 0, it could be 10. It just depends on the month, to be honest with you. Some people want to have trials. Now, remember, for us, a trial would also be a traffic matter. It could be a DUI. It could be battery, domestic violence. It could be a battery. It could be a larceny case. It was a range of things that you see in a smaller jurisdiction with misdemeanors. But a lot of times, people just want to go to trial. So, I mean, I probably negotiated as many as I tried at one point. I think that's been different since I've been here longer. But I remember when I first started, I did a lot of trials. A lot of trials. That has slowed since I've been here because I sort of nuanced the system, and I've just been around a while. And after understanding how things work here, I changed the nature of the way that we do things. And that's what I've done since Dave left.
Yeah, go ahead. Any final points, Mr. Booker?
Anything from you, Lauren? Nothing from Lauren, Your Honor. Nothing from me.
Great. So before I let Mr. Mueller reply on this, one thing that seems to be crystal clear is if Mr. Hunt had not filed the civil rights complaint, then this amended complaint against him, I guess, never would have been filed, and he never would have been prosecuted on these counts. So it seems like there is a cause and effect here, that his filing of the civil rights action led to the charges being filed against him. So I'm just kind of surprised that. Judge,
that's not what led up to it. They had already drafted that complaint.
I know, but it would never have been filed. No one can dispute that it never would have been filed had the civil rights action not been filed, because on the one hand, Mr. Mueller said, well, it was a vindictive prosecution, and your side is saying that he forgot about it and he was reminded about it. Well, either way, he never would have been prosecuted, but for his action of filing the civil rights complaint.
Judge, that's not why it was filed. It was supposed to have been filed earlier. They probably just didn't do it. My guess is, like I said, this was right. You got to remember, he's right in the middle of retiring when all this was going on.
Yeah.
So he set it to the side, probably with the intent of getting it filed, and he didn't get it filed, and he was prompted to file it when this civil case came. He goes, "Oh yeah, what did I do with that?" And then he went and he came on down and he filed it.
All right,
That's not
very good.
Judge. There's nothing vindictive in that. There's nothing vindictive about anything Dave has ever done, for that matter.
All right, Mr. Mueller, any closing comments?
Just very briefly, Judge, the court seems like you're forming your thoughts here. Number one, equal protection. There is no two sets of law. Law in Clark County, law in Elko County, law in Story County, law in Humboldt, Lander. It's the same law. The doctrines apply. Mr. Booker makes a point that the jurisdictions operate differently. I can see that they do. In Nevada and the larger jurisdictions, you have standard procedures that protects defendants. We always do it this way. Okay, so I think everyone gets handled this way. When standard procedures aren't filed, you're like, oh, why isn't that? Then you start looking at why standard procedures weren't followed. In the smaller jurisdictions where everybody knows everybody, that's where the law, this vindictive prosecution doctrine, really needs to be looked at very carefully. Mr. Booker seems to imply that vindictive is a personal motivation. It is not. The court's got your finger on the issue here. These charges don't get filed unless the civil rights charges is filed. Okay, that's a fact. Nobody's denying that. Mr. Booker says he was tickled. I'm saying he was vindictive in that he needed leverage to try to get the civil rights case done. Then backing up my argument that it was vindictive, there's two different explanations as to what happened. Number two, Mr. Booker made a point. He did, and he's referring to Mr. Olson. He said something you should never do. Those were Mr. Booker's words, not mine. Mr. Booker is an experienced, and the court may be aware that for 100 lawyers in town, there's maybe 3 or 4 of them have any criminal experience. Those of us with criminal practitioners all know each other, and we all have 20 and 30-year relationships. And I've prosecuted against some criminal lawyers, and I've defended against them, and actually occasionally appear in front of them. So we're a relatively small cadre. Mr. Booker said, and he concedes, this is something you should never do, voluntary and dismissing and refile. And I agree with him. You don't do that because it creates problems. You always file an amended complaint if you've got the evidence to support it. And number three, you can't get around this. There's just, and Mr. Booker tries to politely say, he says that he should never do it. I saw the files. They were sitting there. The cases, we all agree it wouldn't have been filed. This is, in fact, vindictive prosecution. It's exactly what it is. You were right the first time. I believe that's the proper case, and I'm going to ask the court to dismiss. And in closing, I will just point out Mr. Olson's exact words. I was quickly preparing this complaint to meet the deadline. It occurred to me that this other offense had occurred and that it interfered with a lawful activity. Okay? Or a lawful activity that the police were attempting to perform. So that was indeed a different violation, so I included it. Right there. That's his words. You've seen him. We'll hold him to his words. All right? And this is not a personal attack on Mr. Olson, and we don't need to go there. Vindictive prosecution requires no personal animus, and it requires no emotional or mental state. It is a doctrine. And it is not Mr. Olson. It is the state of Nevada acting through its agency. There's no home rule. Boulder City is his agency of the state of Nevada, same as you are, same as this district courthouse is. They're all agencies of one government. The law applies uniformly, routinely, no matter what the jurisdiction is. And when the jurisdiction gets really small, you got to really watch people's motivations. So respectfully, Judge, you were right. I'm going to ask the court to renew it and dismiss it for vindictive prosecution.
So, yes, Mr. Booker?
Your Honor, if we follow Mr. Mueller's reasoning through to its natural conclusion, anytime someone files a civil case and the criminal then to go ahead and charge him when they're still within the 1 year, you can't do it, and that's not correct. And also, when you look at Dave's affidavit, he's very specific. He says, I was informed that there was additional evidence from the Nevada Highway Patrol that I had not seen, and I believe that the evidence could be important to the prosecution in this case. That's why he dismissed it with withholding the ability to bring it back up again, Judge. That's why he did it. There was no vindictive or no animus, and Mr. Mueller would have you think smaller jurisdiction equals harder or more selective justice, and nothing can be farther from the truth. I think we work in tandem the way they would in the DA's office, but our volume is a lot less, and that accounts for why the DA has 90 or 100 criminal deputies, and Boulder City has 1.
Okay, I got to cut you off there, and I'll give 10 more seconds to Mr. Mueller because he's the movement here.
Every single case has highway patrol video. Meeting a new DUI at the office at 1 o'clock today. The first thing I'm going to do is write down, make sure you get the video, and hand it to my staff.
Okay.
There's nothing new there.
So as we move to the end of the year, the court is trying to complete its review of all matters that it has pending. And so although I'm hesitant to add any matters under advisement, I am going to take a couple of days to think this one through. I want to look again back at the affidavits and the deposition testimony and to see the extent to which they can be reconciled or not reconciled, and do that in the context of the information provided by both counsel today on how things are normally done, which is very helpful to the court.
All right, thank you, Your Honor.
All right, thank you. Under advisement.